Hello. In our second lesson on EU law, I'm going to speak about the Ordinary Legislative Procedure, or the OLP, which I'll call it from now on because it's a real pain to say. The OLP is the typical way that laws are passed in the EU, and it focuses on our three lawmaking institutions. That is the Commission, the European Parliament, and the Council of Ministers. So if you haven't seen my first lesson, I'd advise you to look at it and try and get an idea of what each of these institutions are. In this lesson, I'm going to go over the different voting procedures used and how these institutions interact with one another, bearing in mind that they each have a different conception of what is right in the EU, how their powers are limited, and how they need to cooperate to get things done at the EU level. So, we start off at stage one. The Commission is the only institution which can have legislative initiative. This means it's the only institution which can create law or write draft laws. And so this is what it does. It sends out a draft law and it sends it to both the European Parliament and the Council of Ministers, sorry. And so it sends the draft to the European Parliament. Right before stage one starts, the Commission has an opportunity to revoke the draft bill. Maybe it decides that it hasn't quite got it right and doesn't want the European Parliament and Council of Ministers to vote on it. So they have that power. In any case, it goes to the European Parliament. They can either accept the draft as it is, or they can amend it. Then, if they either accept or amend it, it goes to the Council of Ministers, who can either accept or not accept the bill or the amended bill. Now we come to stage two. At stage two, the European Parliament now has its own trump card. So the European Parliament can choose to kill this draft bill. It has what is effectively a veto. If it doesn't use its veto, and it very rarely does, it then has the choice to accept or amend the bill again. Here the Commission comes in. So if the European Parliament chooses to amend the legislation, which it will have done because it hasn't been accepted at stage one, the Commission can look at what the European Parliament has amended, and it can say two things. Number one, it can say, well, fair enough, good amendment, and leave it at that. Or it can disagree with the European Parliament's amendment. Now, this is a good time to start talking about the different types of voting which are used by each institution. So the Commission doesn't vote, we're not bothered about them for the time being. The European Parliament uses typical majority voting. So you need 50% plus one of the MEPs to vote for your bill. The really interesting system of voting exists in the Council of Ministers. So the Council of Ministers, if you remember, are a group of government ministers from each of the 28, 27 member states. In order to pass through the Council of Ministers, a bill must receive two things, and this is called qualified majority voting, or QMV. The first thing is 55% of member states must accept the bill. Okay. The really interesting aspect is 65% of the population of the EU must accept the bill. And I don't mean literally 65% must accept it, but member states constituting 65% of the population of the EU must accept it. Now, this is what's called a double majority. This is interesting because it means that anything which makes it past the ordinary legislative procedure has been accepted indirectly by more than 50% of our directly elected MEPs, but also ministers representing at least 65% of the population of the EU. So it's very representative. Going back to the Commission's intervention, so if it's the case where the Commission doesn't accept the European Parliament's amendment, they can say, look, Council of Ministers, you can turn this bill into law, but on one condition. you need to vote unanimously. So in stage 2, we see a real toss-up. We see the Parliament's trump card, but we also see a Commission trump card, where if it's not happy with the way that the bill is progressing, it can say, right, it can pass, but the Commission needs to get it through unanimously. So even though the Commission drafts the bill and to some extent takes a step back, they still have a relatively active role in controlling the types of bills which can become law. In any case, fine. Let's say, for example, the Commission are happy with the European Parliament's amendments, and nonetheless, the Council of Ministers still cannot pass the bill at stage 2, so they can't get it past that double majority threshold. We then move into stage 3, and this is six weeks of very intense mediations between these 3 institutions. Those are, of course, the Commission, the European Parliament, and the Council of Ministers. And if they haven't been able to come to an agreement before, the hope is that 6 weeks of intense mediation will hopefully bring about some sort of agreement. So it's very rare that a bill doesn't get passed at all by the end of stage 3. Now, this is, albeit a very complicated one, this could be it, right? But it's not quite it, and indeed, some commentators on the EU, they look at this OLP and they say this is great because it's very representative. You need so many votes at EP level. You need so many votes at Council of Minister in the Council of Ministers. This is great, but you need to gloss this with the recognition that the OLP isn't always followed in the way that we expect it to, and this is due to the enlargement of what we call trilogues, or informal agreements. So, taking us back to the start, before stage 1, it is increasingly common for, in behind closed doors meetings, for representatives from the European Parliament, Council of Ministers, and the Commission to meet and say, okay, this is the draft legislation, let's hash it out, and let's make it so that before the bill is even presented to the European Parliament at stage 1, it will have already been agreed. Now, there are 2 sides to this. The first side is great, because this means things get done much quicker. Look, I'm a fisherman in France. I really need this legislation to get through. Get it done as quickly as possible. The second point of view is this isn't desirable at all, because it allows these institutions to circumvent this very strict system of passing laws. So if we acknowledge that the OLP has been set up in a way to ensure that the institutions need to cooperate and they need to get so many votes, maybe it's the case that by having trilogues or informal agreements, we're losing out on some of the rigour of the OLP. The reality, as with most things, is somewhere in the middle. So yes, it's certainly the case that perhaps some of the rigour of the OLP is gone. However, it's also important to consider that trilogues take place in the shadow of the OLP. So, for example, if the EP aren't particularly happy with a piece of legislation, a piece of draft legislation, they are well within their rights, even though it's a trilogue, to say, look, we're not going to come to an agreement now, let's take it to the OLP. So already we can see that even though legislation is increasingly not passing through the OLP, the checks and balances and cooperation that are designed in the OLP are significant even at trilogue level, because the EP still has a veto, and their veto will still be significant if they refuse to participate in trilogues. The real problem with trilogues then is when we consider the issues of privacy. Is it the case that lawmaking should be made in public, or should we make laws in private? There are arguments both ways, and this will depend largely on what you think about the EU's purpose. Maybe it's the case where the EU can make better laws if it shuts out public opinion. Or maybe shutting out public opinion is bad regardless of the quality of laws. Maybe the public should be able to oversee lawmaking, and this is why we have the OLP, so the public can sit in the European Parliament or watch the Council of Ministers proceedings. These are important questions, and they become increasingly important as the use of trilogues increases. The relatively recent judgment in D. Capitani led to the declassification of negotiation documents in trilogues. So it's now possible to have access to these trilogue negotiation documents. And as we see the levels of privacy decreasing in trilogues, it'll be interesting to see whether the frequency of their use also decreases, or whether it's simply the case that trilogues become more formalised in the EU's legislative process. I hope this video has cast some light on how the EU makes laws. If you like the video, I'd encourage you to like it. I'll upload this and some notes in the description, and I hope to see you again next time.